Hello friends, recently Jan Vishwas bill has been introduced in the parliament. The experts are saying that this bill is yet another bureaucratic encroachment on the judicial powers. So today we will be discussing that. We will analyze the provisions of the bill and we will discuss how this bill is actually a bureaucratic encroachment on judicial powers. If you want to download this slide, the link is in the description box. If you want to listen to this video in Hindi, you can go to our another channel, that is prepezee. The link is already available in the description box. So basically the context is that the Jan Vishwas bill has been introduced in the parliament. And the experts are saying that the judicial powers, that is the power to make a judgment, power to give a decision on a particular dispute. Now bureaucracy is trying to get into that and it is trying to encroach on the judicial powers. So let us understand first the provisions of the bill. See, the objective of Jan Vishwas bill is to improve ease of doing business in India. How does this bill seek to do it? It tries to decriminalize certain offenses. By decriminalization, I mean that instead of making a person or a businessman go to a prison or a jail, we will be imposing a penalty or a fine on that person. So this means decriminalizing, that is, in criminal cases, in criminal offenses, still the imprisonment will continue. But in civil offenses, instead of going to a prison, a person may be able to pay a monetary penalty or a fine and escape imprisonment. Similarly, we'll also make certain offenses compoundable. What do I mean by compounding? See, compounding refers to when two parties to a dispute, in this case the authority and the businessman, they sit together and through discussions they resolve the issue, they arrive on a settlement. That is, the businessman will pay certain amount to the bureaucracy or the country, the treasury, and in lieu of that the businessman will not be facing any prison term. So this is compounding. So these two terms, I hope they are clear: decriminalization and compounding. Now let us have a look at the provisions or the features of this bill. Firstly, 42 acts are coming within the purview of this bill. What are those acts? It includes many acts. For example, Information Technology Act of 2000, then the Indian Post Office Act of 1898, then Indian Patents Act of 1970, then Environment Protection Act of 1986, Prevention of Money Laundering Act of 2002, and many such acts. For total 42 acts are there which will be under the purview of Jan Vishwas bill. It will decriminalize the offenses. As I already said, decriminalization, just to repeat, is the act where we say that the imprisonment will no longer be necessary and the person can escape by paying a monetary fine or a penalty. Now I am using these terms, fine and penalty, but they are different terms. Now let us understand what is the difference between penalty and a fine. See, penalty is basically an executive decision. It is taken by the bureaucracy, and by bureaucracy I mean the IAS officers, the IPS officers, what you are going to be tomorrow. And fine, instead, it is a judicial process. That is the judiciary, a judge, a court. You go to a court and the court, the judge listens to the argument, the investigation is made by the executive, and on the basis of those facts which are revealed in the investigation, the judge takes a decision and imposes a punishment. So that is a fine. A monetary punishment is a penalty if imposed by executive, and a fine if imposed by the judiciary. So please make this term very, very clear in your mind. So here we are trying to impose penalties instead of fine. We are not totally doing away with fine, but instead we are now trying to impose penalties in many such cases instead of fines. For example, see, and we are also decriminalizing, that is prison term we are doing away with. For example, see, Information Technology Act 2000 is there. In this act, if anyone is in possession of certain personal information of an individual and then that person discloses that personal information to a third party, that act is punishable with an imprisonment of 3 years along with a fine of 5 lakh rupees. However, now we are doing away with the imprisonment, in this case IT Act 2000. Rather than that, now we will be going for penalty, but now the penalty will be more higher, that is rupees 25 lakh. So till now it was a fine that is imposed by a court of 5 lakh rupees. Now it will be a penalty imposed by the bureaucracy of about 25 lakh rupees. So I hope this is clear. Similarly, another example is the Patents Act, Indian Patents Act of 1970. In this act, if someone is selling a good or an article and says, falsely the person says that this particular article has been patented in India, and it is proved that the person was lying, then the fine earlier was 1 lakh rupees. But now this fine has been done away with. Instead, there would be a penalty which could be settled without going to a court, but the penalty would be higher and it would be 10 lakh rupees. So I hope this point is very, very clear in your mind, that rather than fine, we are going for imposing more penalties and lesser of fines, so that the person does not necessarily go to the court and waste her time in moving to and fro between the courts and their businesses. Similarly, in certain cases, the offences have been completely removed. For example, in the Indian Post Office Act of 1898, now the offences have been completely removed. So, for example, earlier, if anyone opens the contents or reveals the contents of the postman's bag, then that is actually punishable by imprisonment. But now we have removed away these imprisonments. Now, what is the justification? That we do not know. But what we know is that now this is no longer an offense. Similarly, there would be a revision of fines and penalties. So again, as I just told you, many fines which are there, for example, 1 lakh rupees, it has been increased to 10 lakh and such, in proportionate increase in there. Apart from that, we have also implemented a provision in the bill that the minimum fine would be increasing by 10% every 3 years. That means that right now, if the fine is rupees 10,000, then after 3 years, this minimum fine would increase to rupees 11,000. That is 10% increase. And subsequently, it will keep on increasing like 12100 like that after 3 years and like that. Why? Because see, certain acts, they have been made a long time ago. And let's say Indian Patents Act. And at that time, probably in some provisions, the fine would be hardly 1,000 rupees, which is not a substantial amount in the today's time. So now it has been increased to 1 lakh, 10 lakh rupees, which is actually a substantial amount and acts as a deterrence for some people who are in the position to pay this. Then again, in this, we are also looking at adjudicating officers. A provision says that many acts, for example, the Agricultural Produce Grading and Marking Act of 1937, the Public Liability Insurance Act of 1991. In this, we will now be having adjudicating officers, that is IAS officers, the bureaucratic officers, who will now be looking into imposing penalties instead of the people going to court and being subjected to fines. So similarly, there will be also a provision of appeals in this Jan Vishwas bill. For example, Environment Protection Act. If you believe that the adjudicating officer order is not fair enough, then you can appeal to the National Green Tribunal, NGT, but within a period of 60 days. So appeals provisions are also there. But adjudicating officers, see, please understand, adjudicating officers, they are not judges, but they have judgmental powers and they come from IAS, that is the bureaucracy, IAS, IRS, IPS and such other services. So now we have looked into the provisions. Now let us understand what is the major point here of contention, that is the transfer of monetary penalties to the bureaucracy. This is the important thing for your mains examination. The question will be asked on that, and today we also have a question in the end. So I'm hoping that you will be able to answer that question after listening to this discussion. So monetary penalties will be transferred to bureaucracy. That is something which we are looking at here. For example, as we just saw, Environmental Protection Act, the Air Prevention and Control of Pollution Act 1981 also, all these acts, we are seeing that now the power of imposing fines will no longer be there, and instead monetary penalties will be imposed by the officers of the bureaucracy. And now see, it is also given as the act will come into play, we will see to it that the joint secretaries or secretaries of the government, they will be imposing these penalties. Similarly, under Indian Forest Act, the forest officers, they are empowered to ask the offender to pay an amount. But right now there is no cap on that amount, and it will depend upon the extent of damage which has been done to the forest. However, the problem here, as we see, is that as of now, the business community has not shown any opposition to this provision. That means we are seeing that there is a generally favorable review by the business community also, because they understand that it is very difficult for a person to go to prison. Instead, the person would like to pay some kind of penalty or a fine if a provision is there. So rather than going to the prison, the person, though the penalty or fine will also be harmful to the person, to the financial standing of the person, but instead of going to prison, this is a much better choice any business person will have. However, the problem here is that this is actually against the provisions of the Constitution. When the Constitution was enacted, there was a part which was for DPSPs, that is Directive Principles of State Policy. Now, these provisions which were under DPSP, they were not enforceable immediately after the commencement of Constitution, but the Constitution told the government, directed the government, that as the time passes, as the conditions become suitable, and as you garner more or gather more resources, you will try to implement these provisions one by one subsequently. So Article 50 in here says separation of power should be there between the executive and the judiciary. However, here we see that this is not existing, because bureaucracy is now taking judgments and it is imposing penalties. So there we see a problem is lying. And see, it's not like that separation of powers, the government has not done anything regarding that. Actually, earlier the criminal magistracy was actually a part of executive. That is, the criminal magistrates who are pronouncing judgments in criminal cases, they were earlier a part of executive, but then later on this was turned over to the courts, and now the judiciary, the criminal magistracy are now a part of judiciary. So actually there is some things have been taken to see to it that separation of powers exist. However, we see that bureaucracy has also attempted to capture the judicial power. How? See, there are many provisions. First of all, judicial tribunals have been formed. For example, National Green Tribunal is there. If we look at the constitution of this tribunal, we see that one chairperson is there. Apart from that, minimum 10 and maximum 20 judicial members are there who are picked from the judiciary, that is the courts, Supreme Court, High Court, as well as the district judiciary. Then 10 to 20 expert members are there who are the technical members, and these members are from bureaucracy themselves. So this bureaucracy, now it is a part of a judicial tribunal which has the power to pronounce judgments on the investigation done by the executive. So you see, and these technical members, these experts, they are from IAS, IPS, IRS and such other technical experts which are there in different tribunals they are sitting. So now they are a part of judiciary, a judicial tribunal. So again, this is a bureaucratic attempt to capture judicial power. Secondly, there are statutory regulators. What are statutory regulators? See, any regulator which has been made or created by an act of the parliament is called a statutory regulator. For example, SEBI is there, which has been created through SEBI Act, that is Security Exchange Board of India. Then Competition Commission of India is there. So these are basically headed by senior bureaucrats, that is IAS or other officers, but they also have judicial powers, that is they can impose fines, penalties on the offenders. So again, we see that yet another attempt is there by bureaucracy to see to it that they are usurping the judicial power. For example, see, Competition Commission of India, it can impose monetary penalties or fines in case a company abuses their monopoly. Or companies, they form a cartel and they then decide the market prices of any product or a good themselves without having adequate competition. So these things are there now where IAS officers or bureaucracy is sitting, and yet they are pronouncing, they are giving judgments. Again, adjudicatory officers are there. For example, in this Jan Vishwas bill also you see that in the Information Technology Act, in the Prevention of Money Laundering Act, in the Food Safety and Standards Act of 2006, there are adjudicatory officers who are parts of bureaucracy, and yet they have the power to impose monetary penalties. They can impose monetary penalties also. They can attach the property of the offenders also. By attachment, we mean that they will seize the property of these people. So these things are basically some issues where we see that the problem exists and the executive encroachment on judiciary is not actually tolerable. See, again, we say that in Supreme Court has categorically said that to give any judicial pronouncement, an independent judicial authority should be there. The problem is Supreme Court has never clarified that penalty, whether it is a judicial function or not. So that is why we see that the benefit of doubt has gone to the Jan Vishwas bill, and we'll see in the coming future, we will see whether this provision survives or it does not survive. But we know that this is actually against the rule of law. Why? Because see, rule of law which was given by A.V. Dicey, it says, it gives three provisions. Firstly, there will be no special rights given to any category of individuals. There will be no distinction between two individuals, and no punishment can be awarded to any individual without proper trial. Now, in this case, there is no trial because executive is the one which is doing the investigation and finding the facts of the inquiry, and it is the same authority which is disbursing the judgment. This is not done. Why? Because see, if this is happening, then despite whether the facts are fair or not and the investigation has been done impartially or not, the judgment would clearly be in the favor of executive and against the business community. But an independent judge or judiciary will see to it that executive is wrong and they will rule in the favor of business or the other party. So therefore, this is actually against the rule of law, and this does not stand trial in the constitution as per the provisions of the constitution. So therefore, we see that there is some problem in this bill, but let's see how the judiciary takes it if there is any appeal against the provisions. So now many students have demanded that there should be a question so that they can write answer to that question. Here is the question. Please freeze this slide so that you can write the answer. The question is, do you think Jan Vishwas bill is yet another flashpoint in the ongoing tussle between the judiciary and the executive in the country? Discuss this while highlighting other points of contention between the judiciary and executive. So here, firstly, you have to see to it that what are the provisions of Jan Vishwas bill which are against the separation of powers, and secondly, you have to also tell that what other issues are there which are bone of contention between the judiciary and the executive. So if these points, the other points, you can write these points in the comment section, and if you have written the complete answer, you can either type it or you can even write it and then send us a screenshot at prepezee@gmail.com so that we can give you a detailed feedback on what are your problem areas and how you can improve your answer writing. If you like this article, please like, share and subscribe. Thank you.